Good morning, friends. Today we are discussing the topic drunk and drive, how the cases are disposed and how the cases are charged sheeted by the police, what is breath analyzer test, and how the case is being disposed, that is what is a summary trial procedure. All these things today we have to discuss. At the outset, I have to thank the special judicial magistrate. Of course, name should not be given. So, for interacting with me, and actually, he told me all these points. Even though I worked as a police officer, at that time, so much of influence of the drunken driving was not there. Anyway, so let us quickly get back to the subject. Our topic is drunken driving. That is, please don't drink and drive. If you are drunken, if you are found in a drunken stage while driving or attempting to drive, then you are liable for punishment under section 185 of the ME Act. So normally previously people used to book cases under 184 also, but normally the proper section is 185. What does 185 ME Act say? 185 ME Act says whoever while driving or attempting to drive a motor vehicle, whoever has in his blood alcohol exceeding 30 milligrams of blood detected by in a test by the breath analyzer. If he is there, then he is liable for punishment under 185. The punishment is for the first time, it may be up to 6 months or fine up to 2,000. If it is a subsequent offense, please remember. So normally it will go to the first class magistrate. So the punishment will be for 3 years and the amount may exceed maybe up to 3,000. Here normally whenever you might have seen on so many occasions whenever friends are going after taking some liquor or something, some drinks in a bar and restaurant, and if they go to the outskirts or some other designated place, the police will catch them, they will subject them to the breath analyzer test, and if the breath analyzer test says it is more than 30 milligrams, then the concerned person is liable for charge sheeting. Right? So please remember, normally these cases are called petty cases. According to section 206 CRPC, they are derived as petty cases, and these petty cases are dealt with by special judicial magistrates. Normally they are of the second class. So according to section 13 of the CRPC, special class magistrates are there. They are there exclusively for disposing the so-called simple or petty offences. So previously people, normally the police officers, of course any police officer authorized to stop any person in uniform, and if he has got any doubt, then he has to get the breath analyzer test. Now, what is the provision of law for conducting the breath analyzer test? Please remember section 203 of the ME Act. We are discussing almost all the points of ME Act. Section 203 of the ME Act says, 203. Yes, it says a police officer in uniform or an officer of the motor vehicle department. That means MEI, brake inspector. So he may require any person driving or attempting to drive a vehicle in a public place for a breath test. That is breath analyzer. What is the breath analyzer? So this is a machine, is a test for the purpose of obtaining indication of the presence of alcohol in a person's blood, carried out by means of a device called as breath analyzer, and it is approved by, this device is approved by the central government by notification in the official gazette. Such breath analyzers are only approved, and please remember, if it is more than 30 mg, gone, finish, you are liable for charge sheeting. You have to go to the court of law. Right? Now we have learned. So please remember, two types of cases they will be conducted under 185. Number one is drunken driving. Second is under the influence of drugs. Of course, normally such cases do not come in rural areas, but in cities also definitely they will be there. So under the influence of drugs or in a drunken stage, you are not supposed to drive the vehicle. If you do so, you are liable under 185 ME Act. This is the provision of law So whenever the police book cases, they file the charge sheet under 185 of the ME Act. Previously, they used to add 184 of the ME Act also, that is driving dangerously, 184. Normally, if you don't have a driving license, section 3, so even the owner of the vehicle and the person who consumed the alcohol, both of them will be liable. These problems are there, so all of them will be brought before the court. So, when once you are brought before the court, what is the procedure to be adopted? Please remember, since it is a petty case, the procedure will be to be adopted is according to section 208 ME Act. It is only summary trial. So, summary trial procedure means not just like the ward procedure or summons case procedure. It is a summary trial. Summary trial means the evidences of the witnesses will be taken in brief, the gist will be noted, and the judgment will be delivered on the spot. That is the advantage of the summary trial. So, summary trial also we have learned. Then there are certain doubts for our students that whether the vehicle can be seized or not. Normally, the police, they say keep the vehicle near the police station, or they will tow the vehicle to the police station, saying that after paying the fine or challan amount there, then you can get back your vehicle, which is absolutely not correct. According to section 207 of the ME Act, if you do not have any driving license, if you do not have any certificate of registration, then only the competent officer can seize the vehicle, but not on the other occasions. But please remember, they can impound your driving license, they can seize your license. Of course, they have to give the so-called acknowledgement, everything. But please remember, normally the police do seize the vehicles. Actually, according to section 207, they are not supposed to seize. That too, the seizure will be by a competent officer or MEI. Right? Then, as regards the punishment, after all, they are simple offences. The magistrates are also kind enough. Normally, what they do is, even though 6 months punishment and 2,000 rupees fine is there, normally in most of the cases, they impose the so-called fine only 2,000 or so. Please remember, it should not exceed 2,000. The punishment may be there. Suppose if certain, of course, there are some of the judges who impose the punishment and fine also. That means 1 week you go and stay in the jail. Or nowadays, due to the latest jurisprudence, there are certain judges who ask them to go and do social work like traffic duty, like cutting of the hedges across the national highway, or doing traffic duty, or counseling for that matter. All these things will be taken up. Of course, there is no correct legal provision for it. But normally they are also happening in cities like Hyderabad. Right. So the purpose of counseling here, to remember, normally at the time of counseling, the police will call the parents, and of course it is the duty to inform the parents not to hand over the vehicles. Normally the children underage, the persons who do not have driving license, all these people will be involved in such things. Therefore, for giving a counseling, it is in interest of the society, the police will be doing the process counseling. Then normally the police, previously they used to book cases whatever they like, 184 they used to add, and there are occasions where they used to book the owners are also for giving the vehicles, and they used to seize the vehicles. At this point of time, as regards the vehicles, the police are not supposed to seize the vehicles, right? They can seize under section 207 ME Act. If they seize, they have to send the vehicle to the court. If the vehicle is sent to the court, then you have to file a petition under section 452 CRPC, where the magistrate will order for the release of all these things. So it's actually embarrassing. Therefore, normally we keep quiet, right? So normally here, the so-called magistrate, he observed certain overreach by the police. Normally, the police are expected to conduct the breath analyzer test on a person who is suspected to drive the vehicle or to attempt to drive the vehicle in a dangerous stage. But normally what the police do is, they hide or they keep barricades at certain place, and they ask all the people to undergo the breath analyzer test, which is almost an anonymous test, and the people who get through the test, they will go away. This is not actually not advisable, but of course police do the same. That is the overreach of the police. And there are occasions where the police try to change the accused because the so-called slip, breathe and rise test, it doesn't bear the name. But of course, please remember, time and everything will be there. But there are only maybe 1 in 2000 or 1 in 1000 cases. Normally, this magistrate did not come across such cases. But he says that maybe there may be some instances where the accuser can be changed. And of course, now the judge also, he says that normally he will question about the quantum of sentence. Normally he is in the habit of giving fines only. At the time he will say, so suppose if he is an ordinary boy, if he is an auto driver, even so basing on the status he will impose the fine. Of course he says the maximum punished fine is 2,000, how much amount he will be able to pay. Then he will judge by the presence of the person, of course by virtue of experience also they will be able to understand the capacity of the person, and basing on that only they will impose the fine of 500, 1,000, 100 rupees or like that. So normally then the challa, the receipt will be given on the spot. So therefore there is no scope for harassment for money by the police or by the court staff also. Of course outside some things may happen, let us not bother about all these things. So normally this is the procedure to be followed in case of drunk and drive. You people, so most of you have got so many doubts about the same, and now I think you are clear. So anyway, I advise all of you friends not to take drinks and drive the vehicles. At the same time, you advise your clients also not to do the same. Of course, the government is encouraging to take drinks. Okay, you can happily enjoy drinks, but you take one of your friends to drive the vehicle who doesn't take drinks. That will be better. Otherwise, if you are caught, so as per the magistrate's version, the fine may be up to 2,000. But extra expenses, one day you have to move around the police station, or you have to influence the SI or the traffic SI, other things. Next day you have to attend the court. By morning 9 o'clock you go, by 12 o'clock or 1 o'clock only your receipt will come. Then you have to once again go to the police station, get your vehicle released. All these things, all these troubles will be there. Why getting in touch with all these things now? As a matter of defense, suppose if such case comes, if you want contest the same, there may be some of the government employees who are involved in such things. In such case, the defense will be whether section 203 and 204, breathe analyzer test. So not only the breathe analyzer test, he has to be subjected to medical test. That is an important point. Of course, normally we don't contest. If you want to contest, please contest under section 204 ME Act. But of course, since it is a very small case, if you pay the fine, it's all right. So anyway friends, this is the not brief, anyway seems to be brief, but I have told you so many ME Act legal provisions. Please go through all the legal provisions and enrich your knowledge. Thank you.